ay in part, depende po sa legal and factual basis ng bawat relief na hinihingi po, Ginoong Pangulo. So, pwede ko po bang malinawan lang, Mr. Presiding Officer, tama po bang sabihin ganun din yung kapangyarihan ng ating impeachment court? Maaari po ba na suriin ang bawat hinihinging sabina ng magkahiwalay at magpasya po batay sa legal at factual basis ng bawat isa sa halip po na tratuhin ang buong motion bilang isang all or nothing proposition?
Tatratuhin ng hukumang ito bilang nag-iisang motion ang tag-isang motion na inihain ng prosecution. They only filed 2 motions, Senator Judge Villanueva, and the court will act on these 2 motions separately, regardless of the number of issues or sub-issues underneath each motion. The reason is simple. Because the court should be a passive body. By amending the motion into several parts and voting on it separately, we are essentially acting as if we were one of the parties in voting for or against the motion.
Try this! Coffee ko brown! Saktong timpla ng kape, milk!
That may be raised for or against it. And it may be cited by the Senator Judge in explaining for or voting for or against it. Pangalawa po, bilang mga hukom, hindi tayo pwedeng masyadong aktibong makilaw sa paraan ng mga motion, which is essentially a relief being asked for by a party, sa pamamagitan ng paghahati ng mga motion na yun para pagbotohan ng hiwa-hiwalay. And there is precedent in the impeachment of the late former Chief Justice Corona, where then Senate President, Presiding Officer Enrile ruled that the ruling of the chair on motions are indivisible and may only be appealed in toto and not in part.
Thank you, Mr. Presiding Officer. And it's clear to me now, despite the fact, Mr. Presiding Officer, Your Honors, that if there would come a time na, for example, sa isang sabina, may sinasabina na sa asawa o sa korporasyon na hindi naman relevant at material doon sa kaso, yun lang po, Ginoong Pangulo, ang ating nagiging reservation tungkol po dito. Ngunit naging malinaw po sa akin na magiging isang desisyon lamang doon sa dalawang motion na inihain.
Tag-isang desisyon kada motion, pero pwede, gaya ng nasabi ng pinag-alangalan ng hukom na senador, na pwedeng hindi ibigay yung lahat ng korte ito. Pwedeng iba lamang, parte lamang, at hindi eksakto ng hiningi niya. Pero yun ang pagpapasyan na bilang isang nag-iisang motion.
Marami po salamat. Naging mas malinaw po sa kinatawan na ito ang ruling ng ating presiding officer. May I start raising some questions, Mr. President, Mr. Presiding Officer, to the two parties, Mr. Presiding Officer, just for the guidance of the court, and I think it's important that we distinguish between two separate procedural questions. Una, kung dapat po bang i-produce ang hinihinging records, at pangalawa, kung ang mga records na iyon ay magiging admissible at kung anong evidentiary weight ang dapat ibigay sa kanila. So, let me start by asking our lead prosecutor, Congressman, to our dear Congressman, would it be correct, sir, to say that the issuance of a subpoena merely compels the production of records and does not by itself amount to ruling that those records are admissible, relevant, or entitled to evidentiary weight, Your Honor?
Before the member of the panel for prosecutors answers, he's not the lead prosecutor. The question is addressed to the Honorable Representative Chel Jokno, who is a member of the panel, who is part of the panel of prosecutors, who will be answering your questions. And for the record, on the part of the respondent, answering?
That's correct.
Thank
So that we don't need to identify each one each time anymore for the record.
Thank you.
The Honorable Jokno may respond to the question of Senator Judge Villanueva. You may proceed, sir, when you're ready.
Thank you, Your Honor. Good afternoon to all the members of this Honorable Court. Naisagot na po ata yan ni dating presiding Judge Juan Ponce Enrile dun po sa Corona impeachment case. And if I may quote just a brief portion from what he said, I would like to explain that the resolution of this court was simply to authorize the issuance of a subpoena. And whether those evidence subpoenaed are admissible evidence, given the fact that they apparently appeared in violation of existing laws, is a question that must be resolved in due course. So ang ibig po sabihin, ang hiling lang po ng prosecution ay may labas ang ebidensya, pero wala pa po tayo dun sa punto kung tatanggapin ba nitong hukuman ang evidence na yun, kung siya po ay admissible or hindi.
Maraming salamat po sa inyong tugon, Representative Jokno. Kaya po, nilahad ko po yan nang sa ganoon, may tanong po natin ang defense panel if that distinction is correct, would the defense still maintain that the mere issuance of a subpoena is by itself already prejudicial to the respondent even before the court has ruled on admissibility or weight?
Yes, Your Honor. Good afternoon, Honorable Senator Judges. Yes, while we agree with the position of the prosecution na hindi pa naman pinag-uusapan ang admissibility sa puntong ito, what we are questioning is really yung subpoena mismo po. Dahil sa ating pananaw, ang isang subpoena, at hindi lang sa ating pananaw, but even under jurisprudence, meron pong requirements bago tayo makapag-issue ng subpoena para maging valid yung subpoena na yun. At yun po yung napag-usapan natin nung nakarang linggo na definiteness and relevance. Ngayon, yung twin requirements na yun, para po sa pananaw ng depensa, ay lacking in this case. And that is why we maintain our position as regards opposing itong request ng prosecution sa pag-issue ng subpoena.
Well, at least malinaw po, ang pag-issue ng subpoena, not necessarily opening of records, una, pangalawa, to be presented in court, at pangatlo, to be admitted as evidence by this court. Before I go dun sa requirement, let me ask the panel of prosecutors, si Representative Jokno, dun po sa pananaw ng depensa on alleged fishing expedition, just for the guidance of Senator Judges, this representation would like to clarify one procedural matter. We understand that the concern raised by the defense that the subpoena may be overly broad. And at the same time, we also recognize that the court has a duty naman to determine whether the records being sought are sufficiently relevant and material to the issues before us. So, Representative Jokno, maaari po ba ninyong ipaliwanag kung paano ninyo tiniyak na ang hinihinging mga records ay hindi po simpleng paghahanap lamang ng posibleng ebidensya o tinatawag na fishing expedition, kundi ito po ay mga partikular na dokumento na sa tingin po ninyo ay meron pong malinaw at direktang kaugnayan dito po sa mga articles of impeachment.
Thank you, Your Honor. Ang hinihiling po namin sa mga subpoena ay kaugnay sa Article 2, which involves charges of unexplained wealth. Kung titingnan po natin yung mga jurisprudence pagdating sa unexplained wealth, klarong-klaro po na sinabi mismo ng Korte Suprema na kailangan makita yung buong larawan, hindi lamang po ng mga salin na finail ng isang lingkod bayan, kung hindi lahat ng kanyang kinita, both what we would call lawful and, if there is, illegitimate income. Ang salin po kasi ay parang snapshot lang po yan, year-end, kung ano yung mga assets, liabilities, and net worth ng isang government official. Ang ITR din po ay parang short video lang po yan ng mga transaksyon ng isang taxpayer sa kabuuan ng taon na yon. Makikita lang po natin yung buong larawan pag nailabas natin ang mga bank records. Kasi doon po yung day-to-day na lumabas mapupuo po natin. And in fact, in the case of DOF RIPS versus Merencilia, ito lang pong portion ang babasahin ko. Sabing ganun ng Supreme Court, the failure of the complainant to take into consideration respondent Rafael's net worth from the time he entered government service and the failure to take into consideration all of his possible sources of income in relation to his real and personal properties do not support the conclusion that he has unexplained wealth, considering that his true net worth was not determined. Ito po ay sabi ng Supreme Court, Ombudsman, hindi nyo nagawa yung inyong trabaho. Kaya ayaw po namin tumulad sa nangyari kay Ombudsman dito sa kasong ito. We want to see the entire picture. Kaya po namin hinihingi yung BIR records, pati yung mga bank records, and even the Anti-Money Laundering Council records para makita po natin yung buong story as far as both the assets, liabilities, and net worth are concerned, and the lawful, and if there is unlawful income acquired by the respondent.
Last question no, sa prosecution. No? Sir, binanggit po kanina nung defense panel yung requirements which should be relevant and specific, and kinikilala po natin dito sa korte na yung subpoena is an important tool na available po dito sa impeachment court in the search for truth. Pero kinikilala din po natin na ang mga records na ating hinihingi ay may tinatawag na statutory protection under our laws. Now in this regard, Your Honor, bago po ninyo hiniling ang compulsory production ng mga confidential records na ito, may we know what led the prosecution to conclude that the issuance of subpoena is the least intrusive and most appropriate means of obtaining the information sought? In other words, Your Honor, paano po ninyo masasabi na itong subpoena is not only relevant but also necessary and proportionate under these circumstances?
Ang subpoena po ang tanging paraan para makuha ng itong hukuman ang mga kinakailangan po natin na datos at impormasyon at dokumento. At hindi naman po siya intrusive dahil tulad na nabanggit ko po kanina, ay hindi pa naman ito question ng admissibility. Ang kailangan lang ay ma-produce sa korte yung mga dokumentong hinihingi. The issue of admissibility will come later, and the defense will have sufficient opportunity to object and to oppose. Ngayon po, as far as the particular records that we are requesting are concerned, ito ay nakabatay nga sa nabanggit ko pong desisyon ng Supreme Court na pag tinitingnan natin ang issue ng unexplained wealth, hindi lang po pwedeng snapshot ang titingnan natin. Kailangan mula sa unang araw ng paglingkod ng lingkod bayan, yung kanyang final na salin, lahat ng mga kinita niya ay makita natin. And that will be shown both by the bank records that we are requesting to be produced, as well as the BIR and tax records that we are requesting.
Thank you very much. Depensa po, binanggit niyo po kanina yung relevance, and if I recall it right, last week, the good gentleman, Attorney Poa, made mention about questions on confidentiality, sir, no? And this representation would like to better understand the legal basis of the defense position on confidentiality. We recognize that the law places a premium on protecting confidential information. And at the same time, we are also dealing with a request made in the course of a constitutional proceeding before this impeachment court. At bilang mga senator judges, it's our constitutional duty to try and decide on impeachment cases. Mr. Defense Counsel, yung Section 8-A of the Anti-Money Laundering Act, binanggit niyo po ito last time, which prohibits the disclosure of confidential information. How should this apply to records sought through a subpoena issued by the impeachment court because as I read, Your Honor, Section 8-A, it imposes confidentiality, but it does not expressly create an absolute privilege against the subpoena. There is a distinction between an authorized disclosure and production pursuant to a lawful order of a constitutional body. So, again, my question, Your Honor, where exactly in Section 8A does it say that AMLC may refuse a lawful subpoena from this court, Your Honor?
Thank you for that question, Your Honor. Unang-una, sagutin ko lang po yung pretense ng inyong tanong. No? Sabi nyo, this is a constitutional body, hindi po ba? And as we all know, there is an old legal maxim that the spring cannot rise over the source. No? Ibig sabihin po nun, while the impeachment court is a constitutional creation, it cannot go up over and above the Constitution itself. And when we talk about the impeachment court under Article 11, we cannot read that in isolation. We have to also give due regard for all other provisions of the Constitution, specifically the Bill of Rights, kung saan due process no, ay isang bagay na nakatatak po doon at pinapakita doon ano bang ibig sabihin ng due process. Due process is kasama po sa kalakip ng due process ay ang bawat na nasasakdal ay meron ding pribilehiyo na maging maprotect o maproteksyonan ng mga batas na isinagawa ng mismong Kongreso. So now let's go on to Section 8A. No? As you can see, Your Honor, that is at least for our position, it's an absolute prohibition. Unlike other laws where they created, for example, in the bank secrecy law, meron nakasulat doon, aaminin natin, in cases of impeachment, isang exception. Pagdating po dyan, wala po ni isang exception. It could have been easy, especially since this is a 2021 amendment. No? It could have been easy for Congress to have cited impeachment as an exception if it did actually wish to do so. But it did not, Your Honor. And it is our position that if we were to compel and issue a subpoena against these AMLAC records, we're actually compelling the officials to violate this very section of the law. And that is why we are saying na pagdating sa 8A, absolute po yan. It does not say that there's any exception if any court processes are actually issued to compel the production of these documents. Precisely because ang nasa loob po kasi ng mga records ng AMLAC are intelligence. No? And that's why it's confidential. And once AMLAC determines that they find out that certain transactions are subject to money laundering or should be actually filed in court, the end result is the complaint itself and not the raw data. And that is why, Your Honors, as to the raw data or the information that they receive, yan po ay strictly confidential under 8A.
Thank you for that. Again, I would like to put on record that I was trying to look at that particular section 8A, and I don't see anything that says this court would not have any prerogative as to whether or not we can subpoena bank records. But let me move forward. Perhaps this could be my last question, Your Honor, Mr. Presiding Officer. The Constitution recognizes two equally important principles: confidentiality on one hand and the freedom of information, which promotes transparency and public accountability on the other. So, Attorney Poa, gusto ko lang pong malinawan for the benefit of this representation and our dear colleagues here, being senator judges, may legal distinction po ba between disclosure of information to the general public and the limited production of records solely to this impeachment court in the exercise of its constitutional function? Because we understand that the principle of freedom of information is rooted in transparency and public accountability, especially po when the conduct of a public officer is under constitutional scrutiny. Now, if confidentiality is the concern, would you agree, Attorney Powa, that this impeachment court can impose safeguards on the use and disclosure of the records? Kung maaari lamang po na kung maaari naman po na magpatupad ang impeachment court ng sapat po na safeguards upang mapanatili ang confidentiality ng mga records, bakit po dapat maging hadlang ang confidentiality sa isang impeachment court upang suriin ang mga impormasyon na maaari nga pong may kinalaman sa mga isyong nararapat nitong resolbahin bilang isang impeachment court?
Para sa atin po, no, kung ano man pong hakbang ang pwede o hindi pwedeng gawin ng isang impeachment court tulad ng nasa harap natin na ngayon, it must be confined to the limits imposed by the Constitution and the laws. No? So, kahit sabihin po natin, we are not against transparency. I just want to make that clear, Your Honors. We are not against accountability. But again, as I've mentioned last week, hindi naman porket po that we are all looking for accountability at transparency, isasantabi na lang po natin kung ano ang mga karapatan, hindi lang para sa impeachable officer, pero para kahit sinong Pilipino na nakasaad sa batas, including absolute confidentiality in terms of AMLAC reports, which we are pointing to. So para po sa atin, nakikita ko yung punto po ng ating hukom, no, na paano kung mag-impose na lang tayo ng certain conditions. However, Your Honors, those certain conditions may be allowed for other records, pero pagdating sa AMLAC po, absolute po kasi yung prohibition. And if we were to amend or at least suspend the provision of 8A, then it is as if this honorable court is actually doing some sort of judicial legislation, no? Because we are technically suspending this law for a specific person na hindi natin pwedeng gawin sa iba. That is why, ang sa akin lang po, ang sa amin, sa punto ng depensa, is paano po yun? Meron po bang instances na papayagan na lang natin, isang tabi natin yung batas? At merong instances na hindi? I think, Your Honors, we feel, the defense feels, Your Honors, that in the search for truth, transparency, accountability, we must still work within a framework, which means that we must work within the limits imposed by the Constitution, the laws, and the rules of the land.
Salamat po, Attorney. Mr. Presiding Officer, just a few seconds, just to put on record, ang Senado po ay nasa plenaryo na po yung proposed Bright Act natin na maraming sumuportang mga kasamahan natin. And ito kasama po dito yung amendments to AMLA to put in black and white the circumstances under which bank records, financial transactions may be lawfully accessed by competent authorities, subject always, of course, Mr. President, to appropriate safeguards and due process. So gusto ko lang pong banggitin that indeed, confidentiality is an important legal protection, pero hindi din po ito dapat maging dahilan naman para manatiling mailap po ang pananagutan. Ang mabuting batas ay kayang pangalagaan ang privacy nang hindi po nasasakripisyo ang accountability. Our laws must be able to protect both, Mr. President, Mr. Presiding Officer. Maraming salamat po, Ginoong Pangulo. Maraming salamat po, our councils. Thank you.
Thank you, Senator Judge Villanueva. Your remarks and responses thereto are duly noted and entered into the records. Senator Judge Pia Cayetano is next, I believe. You may proceed, ma'am, when you're ready.
I'm ready to proceed, Mr. Presiding Officer. I'd like to start this discussion with a question that hopefully will allow our kababayans who are watching, listening, to understand the situation. Of course, I pose it also to the parties. If the government had in mind that there's a business, and of course, a particular businessman or businesswoman who is violating a lot of laws pertaining to the operation of their business, be it customs law, BIR, regulations. Can they just proceed and pwede ba silang basta na lang mag-request ng dokumento o mag-file ng kaso na requiring the businessman and the corporation to produce those documents? Pwede ba? So yun ang pag-isipan natin, no? Kasi yun ang tanong eh. Similarly, ginagawa ko lang ng ibang analogy para maintindihan ng mga kababayan natin. So this is the essence, dear colleagues, parties, of the principle of due process. This is ingrained in our Constitution. Totoo po na may karapatan ang gobyerno at obligasyon ng gobyernong patakbuhin ng maayos ang gobyerno, but it is always with due respect to the rights of every individual Filipino. That is the right to life, liberty, and property. So bago mo sagasaan yung right to life, liberty, and property, siguraduhin mo lang na may basihan ka. Yun lang naman ang sabi. So of course, ako, gusto ko talaga na maayos ang patakbo ng gobyerno para if somebody's life is also in danger, then government has to step up and prevent somebody's liberty. Kasi nga, sinasagasaan niya yung life and liberty ng ibang tao. So it's a balance. No? I think we can all agree it's a balance. So I want to go straight into a landmark case, and I will ask both parties for their legal opinions on it kasi it is a legal proceeding. Pero gawin nyo lang simple para hindi masyado complicated para sa mga nakikinig sa atin. So in the landmark case of Stonehill versus Diokno, 1967 pa po to, karamihan ng mga lawyers hindi pa pinapanganak. The importance of due process was highlighted, and the Supreme Court discussed 2 points. General warrants are void. Sabi ng Supreme Court, a warrant must be issued on probable cause for one specific offense and must particularly describe the thing being seized. So kailangan particular ang description dun sa warrant. Warrants that leave it to the discretion of the officer serving them to decide what to seize, or general warrants are outlawed by the Constitution because they place the sanctity of the home and privacy at the mercy of prosecutors. So sinabi dito na kailangan specific. Take note, warrant ito ha. So naman ang pinag-uusapan natin. Alam ko po yun. Pero I'm pointing it out kasi ang magiging tanong ko later on is kung relevant ito sa kaso. Okay? The other principle that was established in Stonehill versus Diokno was the exclusionary rule. Evidence obtained through an unconstitutional search is inadmissible for any purpose in any proceeding. Ito po yung tinatawag na the fruit of the poison tree. Pag nakuha mo yung information dun sa bawal na paraan, kung ano yung information mo, bawal ipakita yun. And this is where I need to get guidance from the presiding officer. If I'm allowed, I don't have to name names, to share the discussion that we had in caucus para lang mabanggit ko na ito yung mga provisions of law na napag-usapan. Am I allowed to do that? Would you like me to approach you? Please let me know because I will abide. Basically, because ang nangyari is we had our own discussion and I want to mention the provisions of law that we discussed. I don't have to mention names.
The lady may proceed.
Okay, thank you. So, tungkol dito sa exclusionary rule, ulitin ko, fruits of the poison tree, dun nga sa aming very open discussion, and I thank many of our colleagues who were I think we engaged in a fruitful discussion for some, not for all. I think yung iba talagang gustong makipag-debate at di-debate kasi gusto ko rin matuto, no? I think all of you will attest na I also wanted to learn from all of you kung anong perceptions nyo sa batas, kung ano din yung sinasabi ng mga abogado nyo. So dun sa fruits of the poison tree, sabi ko, kung yung pinanggalingan ng mga dokumento bawal na kunin ng basta-basta, then paano mo gagamitin? And meron kasing observation na lumabas na kasi yung documents na yon sa House. So nakita na ng publiko sa House. So sabi ko, pero if I will look at, and this is where I will pose the question to all of you, no? Medyo layered so pasensya na sa medyo complicated. Yung isang concern ng defense na nabasa ko is that hindi nag-allege ng ultimate facts. Hindi klaro kung ano yung naging kasalanan at hindi na-identify ng maayos itong facts na to that lead to a conclusion of law. So, wala daw yun. Later on, I will ask both parties again to also clarify that. But the point is, kung walang basihan yung paglabas ng ebidensya na yon, it is the fruit of the poison tree, then you cannot use it. So, yun yung importante dito kasi I'm sure nakita nyo na sa korte kahit sabihin nyo pong sa mga legal drama na na-throw out. The case is thrown out because na-violate ang due process. So that's the discussion I want to have. I want to hear both ha. Wala akong kinikilingan dito. I'm just explaining na yun yung argument ng defense na walang due process, kulang at why prosecution would you say na nasusunod yung due process. And before I give the floor to the parties, yung sinabi kong kaso na Stonehill versus Diokno, very interestingly, involves the esteemed father of our colleague, Congressman Prosecutor Chel Diokno. In the case of Stonehill versus Diokno, the father of Congressman Diokno was the Secretary of Justice. And in this case, the government, through the Secretary and other prosecutors, suspected that Harry Stonehill and his associates and several corporations that they controlled were violating central bank laws, tariff and customs laws, Internal Revenue Code, and the Revised Penal Code. So nag-request sila ng issuance of search warrant. At ang gusto nilang tingnan is books of accounts, financial records, vouchers, receipts, ledgers, etc. and other documents showing all the business transactions. Stonehill and the other petitioners filed a petition before the Supreme Court arguing that the search warrants were general warrants because they did not particularly describe the things to be seized. So, general pa pala yun. Books of accounts, financial records, receipts. General pa pala yun. And the Supreme Court ruled that indeed, general warrants are void. Warrants must be based on probable cause. Nasabi ko na yun, ano? And then the case also adopted the exclusionary rule holding that evidence seized under an unconstitutional warrant is inadmissible. So, I now pose my questions. Applicable po ba ang kaso na ito, Hill versus Diokno, as far as the prosecution is concerned? And then also for the defense, applicable. Take note, I've read most of the pleadings. Well, all of the pleadings, mahahaba sila. I kinda know your answer, but sa dami, I like to hear it again, and I think, of course, karamihan ng kababayan natin did not read it. So explain natin sa kanila, because this is a landmark case. Kung ikaw ay law student na magbabar, ito yung mga kasong titignan mo. So malay mo, matanong yan sa bar. So nakatulong man lang tayo dun sa mga bar students na maliwanagan sila. Baka mamaya trick question to. Is it applicable or not? That is my question. I will sit down, and then I will come back for my next. Thank you.
Thank you, Your Honor. If I may be recognized.
The member of the panel of prosecutors may proceed to give his answer. Thereafter, the counsel for respondent may do so as well.
Iba po ang konteksto ng search warrant na naging main issue sa Stonehill versus Diokno. Sa konteksto po natin na sa PINA ang pinag-uusapan. Ang search warrant po, ang governing law po dyan ay nasa Bill of Rights natin, Article 3, Section 3. At kaya siya nandun dahil very invasive po ang search warrant. Pag ang isang judge ay nag-issue ng search warrant, pwedeng pasukin yung opisina o yung bahay ng person involved, pwedeng halongkatin yung lahat ng mga gamit niya doon sa kanyang opisina o sa kanyang bahay. Kaya po naglagay ng maraming limitasyon ang ating konstitusyon dahil marami ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso na nangyari kahit noon pa. Iba po ang pinag-uusapan natin ngayon. Ang pinag-uusapan natin ngayon ay subpoena. Hindi po ito license to enter an office or to search any place. Ito po ay mismong humihiling lang ng mga dokumentong nakasulat sa loob ng subpoena. Therefore, the contexts are very different. When we speak of a search warrant, I do agree there should be very specific limitations on how that warrant can be. Pagdating naman po sa subpoena, meron din po yan, but that is not governed by the Constitution. It's governed by Rule 21 of the Rules of Civil Procedure, which basically provide that for a subpoena to be valid, it must be relevant and it must be definite. Ibig po sa relevance ay may kinalaman na may kaugnayan yan sa mga kailangan patunayan ng mga facts. At ang pagdating naman sa definiteness ay klaro kung anong mga iba't ibang dokumento ang hinihingi. In our case, we respectfully submit, Your Honors, that we have met both the standards of relevance and materiality. The BIR records, the bank records, and the records of the Anti-Money Laundering Council are relevant to the facts in issue pertaining to the charges of unexplained wealth. Hindi po natin malalaman kung talagang merong unexplained wealth ang Vice President kung hindi natin mabubuksan yung kanyang mga bank records, kung hindi rin natin makikita at may lalatag ang anti-money laundering at PIR records po nila. And insofar as definiteness is concerned, we have specified the particular documents that we are requesting, and we have included as well an explanation of why those are important. Kaya sa aming pananaw po ay we have satisfied the requirements for a subpoena to sustain. Thank you.
Mr. Presiding Officer, before we recognize the defense, a quick follow-up question.
Hindi po nila.
Bigyan ko ng time na bulungan muna siya ng kasama.
I'm sorry.
Okay na kayo? No, it's okay.
Senator Judge Pia, would you like the counsel for respondent to answer?
Not yet, Mr.
Not yet. Okay.
The request was if I
Okay.
I'll just ask a follow-up question.
You may proceed, ma'am.
Thank you for that. I appreciate his honest response. May I simply point out, and again, please give me your explanation. Tama ho yung pagkabanggit nyo na yung nature ng search warrant very invasionary, di ba? Because it requires that pasukin yung bahay, halugugin yung gamit. Pero hindi kaya invasive din yung paghalugog ng records? Is that not extremely parallel? I mean, is it not very similar in the sense that what is being questioned now are the very essence of somebody's savings, earnings. So, which we have to agree. I think there's no doubt that that is protected. But in fact, His Honor is saying that it would fall under the police power. So, imbis na papasukin mo sa bahay na nandun yung mga dokumento, you will do the same by asking these agencies, whether it is the BIR, the banks, or AMLA, to now reveal these documents. So that's my question. Is it in the prosecution's, is it the point of view of the prosecution na iba yun? Hindi ba invasive yun? Kayo gumamit ng word na invasionary, no, but I'll use invasive, I think. Yeah, anyway, please answer, and then we'll give the floor to the defense, Mr. Presiding Officer.
Counsel for the panel for prosecutors may
Thank you, Your
answer as he pleases.
Yung pong search warrant, kung ano man ang makuhang ebidensya doon, ay direktang binibigay po yun sa court, and that is now considered as evidence by the court that issued the search warrant. Iba po ang subpoena, dahil pag naglabas ang isang hukuman ng subpoena, itong mga records ay hindi po siya considered yet as evidence. Yan po ay ipoproduce lang, dalhin lang po sa korte, and now it is up to the parties, and I refer to both parties, to decide which of those documents may be relevant in terms of the evidence that they are they need to present. Yung pong nakikita po natin sa subpoena, it is not in any way invasive, because as I mentioned earlier, and as pointed out by Senator Enrile when he was the presiding officer in the Corona trial, we are simply having those documents produced. The admissibility of those documents will only be determined after, if offered by the parties. Kaya po sa aming mga pananaw ay malaking-malaki ang pagkaiba ng search warrant sa subpoena.
Your Honor, may I be...
With the permission of the lady Senator Judge, counsel for respondent may now give his answer to her query. You may proceed, sir.
Thank you, Your Honors. Your Honors, ang posisyon po ng depensa dito ay subpoena and a search warrant are very much similar and that both are compulsory processes. No? So, yes, hindi tayo papasok sa bahay ng isang tao o ng nasasakdal, but it will be intrusive because we will be opening up all the financial transactions for, sabi nga dito, almost 20 years of the respondent. Kaya po, katulad ng isang search warrant, the things that we are asking for through a subpoena must be particularly described. Kanina po, nabanggit po ng aking kagalang-galang na opposing counsel na particularly described na po yung kanilang naisulat. However, the defense does not agree with that proposition because if you look at it, tama naman po, nakasulat po dito ng hinihingi nila ay account opening and maintenance records, KYC documents, information files, signature cards, all account and transaction records, ledgers, journals. Basically, Your Honors, this is everything. Ibig sabihin, ni-specify lang nila ang nilalaman ng lahat ng bank records ng respondent. So in our view, Your Honors, while they took pains to specify each and every document, the truth of the matter is they're asking for everything. Ngayon, pagdating sa subpoena, even in the case they cited, yung Rocco versus Contreras, no? Nakasulat po doon that for subpoena to be validly issued, when we talk about particularly describing yung kung ano yung hinihingi, it has to be evidence that is both relevant and material. So ang tanong namin, saan ba dito yung relevant or material? Kasi lahat na po ng records hiningi eh. So, and this bolsters our theory, of course with all due respect to the opposing side, na kaya namin tinatawag o kaya namin natawag na fishing expedition ito. Kasi lahat na ng records hiningi, pero hindi naman matukoy which would actually be relevant, which would actually be evidentiary to the accusations they have made under the articles of impeachment. So, pero dito, hiningi natin 20 years worth of records.
Hello?
And then, paano po yun?
Ah.
Hihimayin natin.
Ah.
Maghahanap tayo ngayon kung may relevant
May bayad
o
ba?
wala. Which brings me back
Okay.
to yung BIR records. Nakaseal po yung box. So I would say, both parties, hindi natin alam kung anong nasa loob nun. Yet, we're hoping na somehow, pag nabuksan yung box na yun, meron po tayong makikitang ebidensya. And that's why, again, with all due respect, we called it a fishing expedition. Kasi hindi naman na-identify kung ano mismo doon yung pwedeng ebidensya laban sa sinasabing unexplained wealth umano ng Vice Presidente. So, with the question, for us, yes, the Stonehill case, Stonehill versus Diokno, directly applies to the current proceedings. Kasi nga po doon, sinasabi talaga na dapat specified yung hinihingi, particularly described and relevant. But as of this point, they're asking, Your Honors, for all of these things. And again, while they specified each and every document, kung babasahin niyo po ng mabuti ito, they're actually asking for all bank records without, in fact, telling us which transaction is relevant to their accusation, which transaction will actually support their accusation. Yun po yung aming pananaw dito sa tanong ng ating kagalang-galang hukom. Thank you po.
If Your Honor, please may be allowed to respond.
Hold on, counsel for the panel of prosecutors. Senator Judge P is the one asking the questions. Unless it's not a debate between the two counsels, you're merely responding to answers from questions by senator judges.
I actually prefer not, pero alam mo na, baka sabihin naman na may bias tayo pag di ko naman pinayagan. Di ko pinayagan.
No,
I defer to...
Senator Judge Pia, you asked the question, they answered. It is not for the opposing counsel to answer points raised. They had that chance when they did their oral arguments, rebuttal and surrebuttal. You may proceed with your question, Senator Pia.
Sige, my question is, what is your question? Or what is your comment? Go ahead. But keep it brief. Keep it brief.
Thank you so much, Your Honor. I just wanted to point out that this is the first time actually an impeachment court is faced with the challenge of determining whether the charges of unexplained wealth are valid or not. And yung previous Corona case, hindi po pinayagan ng impeachment court yung Article 2.4 ng Article 2. At kung ang magiging batayan po natin ay yung naging mga desisyon ng ating Korte Suprema, sinabi mismo ng Supreme Court in several cases na pag ang usapin ay unexplained wealth, kailangan makita yung kabuuan ng kinita ng isang lingkod bayan at yung mga dineclare niya sa salian. Just to quote just a very short portion, sabi ng Supreme Court from the same case I cited earlier, the Ombudsman's failure to account for all lawful sources of income, including proceeds from business ventures and government benefits, further weakens the allegation that Rafael's wealth was unexplained. The incomplete assessment disregarded his accumulated assets over decades of public service.
Same opportunity, I'm assuming.
Yes, Your Honors. Again, hindi ko po tinutuligsa o ino-oppose yung mga na-mention na case ng aking distinguished opposing counsel. However, those cases do not involve impeachment. And why is that relevant? Because in impeachment, as we have said, merong allegation ng unexplained wealth, pero wala naman pong nakasuporta ng mga documents para makita natin ano ba yung basis na naging allegation. Pangalawa po, again in impeachment, according to the case of Duterte versus House of Representatives, meron po tayong tinitingnan kung ano pa talaga ang impeachable offense. At yun po ay again, offenses or acts or omissions committed while the public officer is occupying the impeachable office and in relation to such office. That enough, Your Honors, is very clear under the decision. That is all, Your Honors.
Thank you, Counsel for Respondent. Senator Judge Pia, may proceed.
Mr. President, Mr. Presiding Officer, I'll go to my next point, but it will kind of overlap with this point as well, so bear with me. My next point, Mr. Presiding Officer and parties, is still on due process. This is the requirement that every pleading must allege ultimate facts and must not contain conclusions of law. So again, I'll start with an example. If for example, if there is a case filed, no, and sabi, si Juan robbed the house of Mario. So para maintindihan ng mga kababayan natin, Juan robbed the house of Mario. That is a conclusion of fact. Nangyari na daw yun. And if there's another allegation that says, therefore Juan is guilty of robbery, that is a conclusion of law. So, again, I try my best not to be technical. I would have wanted to be a teacher, if not a lawyer, so I do like to be able to explain things well. Patunayan yung facts mo. Yun yung kailangan sa ultimate facts. Kailangan mo patunayan bakit mo sinasabing Juan robbed the house of Mario. Di sasabihin mo, ang ultimate fact dyan example is si Juan ay nakita dun sa vicinity ng bahay ni Mario. Tapos eto si Mario, narinig na nagsisigaw na ninanakawan kami, whatever. Tapos yun, meron siyang testimonya na ano yung nawala sa kanila. Tapos may nakakita na kamukha ni Juan yung nandun. Tapos namukhaan nila, na-describe nila na 5 feet 10, medyo mapayat, gano'n. So yun yung mga ultimate facts na later on sa evidence patutunayan. That's just very general, no? And then later on, para nga mapatunayan yung robbery, allege na yun yung elements of the crime that constitute robbery. So, nung di pa ako abogado, di ko naman alam ang difference ng robbery and theft. Yung robbery kasi qualified yan eh. So, pumasok siya sa bahay using violence. That's what makes it robbery. So, kailangan i-allege yun. Sorry to be a bit technical. Alam kong yan ang phrase of the day. Let's not be technical. Phrase of the week, phrase of the month. But we have to be able to explain these things in a way that people understand without forgetting that these are rights of the defense and rights of the person who is being tried here, and kailangan maliwanag yung ating mga accusations. So, my question now goes to both the prosecution and the defense. I know that the defense, in their answer, questions the failure of the complaint or the articles to allege ultimate facts, and therefore I think they filed a case before the Supreme Court. I'll give you your time to answer because I don't really recall that I heard it mentioned in the oral argument. So again, with the permission of the presiding officer, papasadahan ko lang naman na nabanggit ko yun na nandyan yan sa nandun sa memorandum, pero hindi ko naalalang, I'm just speaking naman for myself kung ano yung mga sinabi ko dun sa aming meeting, na hindi ko naalalang nabanggit. Baka naman nasabi, hindi ko lang naalalang na-emphasize kasi nga limited yung time. But I do recall that it's in the complaint, it's in the answer, and then it's also in the memorandum. So, pinopursue nyo pa ba ito? Kasi me as a judge, importante ito kasi ano ba didepensa ng maayos kung hindi nga nag-a-allege ng ultimate facts that go into the case. And then, for the prosecution naman, may I ask you kung saan without, because bawal ho na tanungin ko for you to state your case. I cannot do that, no? But what I'm asking is if you can point out sa inyong articles kung saan doon yung allegations of ultimate facts. Kasi public document naman yan eh. Para lang maaral ko na asan dyan yung allegations nyo of ultimate facts. And this is where, before I pass on the floor to the parties to answer, I want to go into the principle of fishing expedition. Nagkataon na I came across the trial that we had for former Chief Justice Corona, and lumabas yung issue na yon. Nasabi ko, eksakto ito yung pinag-aaralan natin for today. Yung fishing expedition, and no less than the defense had to explain it in Filipino kasi sabi, baka hindi alam yung ibig sabihin ng fishing expedition, pangingisda ba daw yun? Parang hindi naman daw yun yung translation, no? Pero ito yung naghahagilap ka ng ebidensya kasi wala kang ebidensya. So, I'll go back to a case and sama niyo to sa response nyo. Doon po sa kasong Afoluhencia versus Metrobank in 2014, humingi dito ang petitioner ng motion for issuance of subpoena ducis tecum ad testificandum at sinabing padala daw ng documents relative to their loan to Metrobank as well as those covering extrajudicial foreclosure. Sabi ng Supreme Court, this is tantamount to building their whole case from the evidence of their opponent. Bawal daw yun. Hindi daw pwede na yung kaso mo, nakabase lang dun sa, sasabihin mo dun sa kabila, labas mo nga lahat ng meron ka dyan. No, your case has to be built. Yung evidence mo has to be there. So I will also ask both parties, is that jurisprudence relevant to this case for the prosecution and then also for the defense? And then let us also include a discussion on why this is or is not a fishing expedition. Yun nga, napaka-importante po kasi ito dahil it is ingrained in a complaint na yung allegations mo ng ultimate facts, mapoprove mo ngayon yon with the evidence. Hindi pwede na wala kang ebidensya, hihingin mo lang ng hihingin by way of subpoena. Clear po yun sa batas. Kaya nga gusto kong ipaliwanag nyo sa akin, educate me why this applies, why this is not a fishing expedition, why the case I cited does not apply, because I assume that's the position of the prosecution. And then for the defense, ano naman po yung position niyo? Salamat.
The counsel for respondent will give this answer first with respect to the question of Senator Judge Pia on ultimate facts as well as on fishing expedition. Thereafter, counsel for the panel of prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor. Pagdating po doon sa sinasabi namin na lack of ultimate facts, no, ito po ay nagsimula pa lang doon sa Committee on Justice when the impeachment complaints were filed. Because the allegation, and I'll stick just with this, I believe, Article 2. Pagdating po kasi doon, there was an allegation of unexplained wealth. Pero wala pong nakasulat kung saan nila nakuha, ano yung basehan ng unexplained wealth na yon. Ano yung act na ginawa ng Vice Presidente, kailan yon ginawa. At so sa amin, para masabi nilang nagkaroon ng unexplained wealth. Ang basic, if I may remember, was really just the fact na yung SALN niya ay lumaki from 2007 to 2025, which sa aming palagay does not show any factual allegation whatsoever, except for the fact that it grew bigger over a span of 20 years. Pangalawa, wala rin pong naka-attach, which I mentioned in oral arguments last week, na kahit anong ebidensya or kahit supporting document man lang, huwag na nating tawaging ebidensya, supporting document that will support any allegation whatsoever of unexplained wealth. And that is why, nabanggit ko rin, na after the allegations were made, and this is even more significant, after the respondent had filed her answer, na tinawag pa nga nilang non-answer, doon lang po naghanap ng mga ebidensya na sakaling makasuporta doon sa aligasyon na yon. That's very important for us because we had already filed our answer before AMLAC documents were suddenly produced with the issuance of subpoenas, before the BIR box was concerned, that we are concerning ourselves with was presented before the Committee on Justice. Nasa panahon na yun, tapos na po kami sagot. In fact, when they were saying that it was a non-answer, to be very candid with everyone, we wanted to say because it was a non-complaint. Kasi walang ultimate facts na naka-allege for us to even answer. Now, before this honorable court, I do recall that in our answer, we also took pains to discuss the lack of ultimate facts and also what we feel were violations of due process before the Committee on Justice, or at least with the proceedings that were conducted before the Committee on Justice. And that is also why we have a pending motion for exclusion na ikinalakip namin dun sa answer precisely because we were objecting to the fact that these pieces of evidence were produced after we had already filed our answer. Now on the fishing expedition, I think on the fishing expedition, Your Honors, our main point is this. Even if we read the twin requests for subpoenas, ulit-ulit po, nakasulat po doon, because this may show context, because this may show, prove something. At para sa atin, this only shows, and at least, again, on the part of the defense, this is somewhat already an admission na hindi pa nga nila alam kung ano mismo doon sa mga hinihingi nila ang pwedeng sumuporta sa mga aligasyon na unexplained wealth. And that's why, if you read the entire request, it uses the word may several times, and it even says in one paragraph, I think it's 3.24, but I might be mistaken, that at least with the request for, with their memorandum, rather, in their memorandum, nakasulat po doon that this does not assume wrongdoing, but they want those documents nonetheless to see if something there will actually help support their allegations. That is why we are calling it a fishing expedition. Dahil in Tagalog, para po maintindihan, sa aming pananaw, sa dami ng hinihing dokumento, para po itong nagtatapon po tayo sa dagat ng isang napakalaking lambat, at umaasa tayo na kahit papaano may mabingwit kahit isang pirasong ebidensya. Maraming salamat po.
Counsel for the panel of prosecutors, the Honorable Jokno.
Thank you, Your Honors. The question propounded to this representation first is, what are the ultimate facts alleged in the articles of impeachment? Yun po ay nakasaad sa page 7 of the articles. And if I may be allowed to just read them briefly.
You may do so, Counsel.
Thank you, Your Honor. Respondent Vice President Sara Z. Duterte committed culpable violation of the Constitution and betrayed the public trust when she amassed unexplained wealth manifestly disproportionate to her lawful income and earnings during her incumbency as a public official. B. Failed to fully and truthfully disclose all her and her spouse's assets, liabilities, and net worth in her statement of assets, liabilities, and net worth, including in her salents for the years 2022, 2023, and 2024. And C. Failed to divest and instead willfully continued all her business interests during her tenure as Vice President for the years 2022, 2023, 2024, and 2025. Please allow me to briefly explain why these are ultimate facts. Ultimate facts are basically the essential factual elements that make up a party's cause of action or defense. Halimbawa po, pag murder, treachery, evident premeditation, lahat ng mga kinakailangan ng batas para mapatunayan na murder po siya. In our case, we are alleging, first of all, unexplained wealth. And based on the jurisprudence, the elements of unexplained wealth, the factual elements are amassing unexplained wealth, manifestly disproportionate to one's lawful income and earnings during one's incumbency as a public official. So, nasatisfy po namin yung requirement na pag-allege ng ultimate facts or essential factual elements sa tatlong bagay na po ito. The evidentiary facts follow in the succeeding pages of the articles. Doon po namin dinetalye kung ano yung mga iba't ibang paraan kung paano nakuha o naamas ni Vice President yung ang sinasabi natin na unexplained wealth. On to the issue of fishing expedition. Yung pong fishing expedition po ay halimbawa may sabina na baka sakali meron tayong makita. Yun po ang ibig sabihin ng fishing expedition. When the party requesting information does not know what might be produced and just as an off chance tries to use that instrument in order to gain evidence that may be used against the other party. Dito po, malaki ang pagkaiba ng sitwasyon. Maalala po ninyo, during the hearings before the Committee on Justice, the Executive Director of the Anti-Money Laundering Council testified and produced documents showing that from 2007 up to the present, 6.7 billion pesos ang dumaan po sa account ni Vice President Sara Duterte. On that basis, and if we go deeper into that report, it says that during the period from 2007 to 2013, during the time that she served as mayor and vice mayor, umabot po sa halos o lampas 3 bilyong piso ang dumaan sa kanyang mga accounts. So may basehan po tayo para ipalabas ang bank records. We are not just guessing that there is something there because the AMLA itself has confirmed that there were covered and suspicious transaction reports submitted to them in those amounts that I mentioned. Malayo po ang fishing expedition sa ginagawa ng prosecution dito po. If we had no basis at all, if we did not know what was in the AMLA reports, ayun po, maaring sabihin na fishing expedition. But in this particular case, we know because these are matters of record presented before the Committee on Justice. Second po, ang fishing expedition, maaring magamit yan sa ibang mga alegasyon tulad ng baka meron kang hindi na-declare sa iyong SALN. But when it comes to issues of unexplained wealth, it's very clear. The decisions of the court are very clear. To know whether a government official has amassed unexplained wealth, we must look at the entire incumbency of that official. Starting from day one, we look at their SALN, we look at all the income that he or she has earned, both lawful and not, and from there we make a determination whether there was unexplained wealth or not. For these reasons, Your Honors, the fishing expedition argument, in our view, is totally untenable.
Senator Judge Pia, do you have further questions?
It's actually just a follow-up to what the prosecution, how the prosecution responded. I think Senator Alan Peter will go into it, but since this is my line of questioning, I'll follow up lang on this point. No? His Honor, I earlier mentioned the fruit of the poison tree doctrine. And ulitin ko, pagka yung pinanggalingan ng information nyo, bawal, hindi nyo na pwedeng gamitin yon. So, His Honor said, I'm referring to Congressman Prosecutor Chel Jokno, they know the contents of the AMLA report, something to that effect, because it was presented in the impeachment hearing in the House. That is correct, right? That is your statement?
Yes, Your Honor.
Yes, oo. And I asked my question again. I will give both parties the opportunity to respond. Ano yung basihan na i-reveal ng AMLC and their representatives sa inyo in the impeachment? Ang nakasaad sa law, I don't even want to use my understanding of the law because it's what is read in the law, and I won't take up the time of this court na isa-isahin ko yun, pero nakasulat doon na confidential ito. So, ano yung basis na mailabas yun doon sa impeachment court? And since the mga allegations na meron kayo. So that's my question. And during our caucus, isa din sa lumabas na discussion, pero allowed ang AMLC and the specific officers to share that information. But the specific provision of the law, and please, both councils, please respond, please elaborate on how this supports or does not support your case. A specific provision dun sa batas, yung sharing of information na yun, sabi, oy, kayo AMLC Council, mag-develop kayo ng rules kung paano kayo makakapag-properly share sa agencies. I believe, and again, you feel free to elaborate on this or correct me, that's referring to the bank institutions, the AMLC hierarchy, and the agencies they deal with, not in court, because ulitin ko, nakasulat doon, confidential. So, I will leave this here, that if it is confidential, it does not allow that this be divulged in the manner it was divulged, then how do you use that? Because that is precisely the doctrine of the fruit of the poison tree. Please take your time to tell us why that information is not the fruit of the poison tree, and obviously for the side of the defense, they will tell us why they believe that it is the product of the fruit of the poison tree. Thank you, Mr. President.
Counsel for the panel of prosecutors.
To prohibit or prevent leaks by officials of the Anti-Money Laundering Council, but it was never intended to prevent subpoenas coming from courts, including the impeachment court. Almost every week, the Sandigan Bayan issues subpoenas for AMLA records. And despite what would appear to be a very categorical prohibition contained in that section, every time subpoenas are issued by the Sandigan Bayan, they are honored by the AMLA and no one is questioning them. Ganon din po itong impeachment court. The subpoena issued by this impeachment court is for the purpose of determining accountability based on the power that is expressly given by the Constitution. Ang aming pong paniwala is that confidentiality cannot trump accountability.
respondent may
Thank you.
reply.
Thank you, Your Honor. I cannot verify if indeed the Sandigan Bayan, as mentioned by opposing counsel, issues subpoenas against AMLA every week. So that I will not comment on because I cannot verify that. What is clear to us, Your Honors, as we have demonstrated last week, is that 8A is an absolute prohibition. And again, this was the latest amendment of the law back in 2021. And for us, Your Honors, that is why when this was presented, the House Committee on Justice, we had our objections to such matter. And in fact, Your Honors, it is a subject of our petition, the Supreme Court, and aside from that, a subject of our motion for exclusion before this Honorable Court. Ngayon po, sa atin, talagang yung tinutumbok natin is, it is in fact within the fruit of the poisonous tree. In fact, I'm surprised, Your Honors, because, Your Honors, nabanggit na rin po ng aking distinguished opposing counsel na nakita na nila, may records na sila. In fact, if I'm not mistaken, it was also attached to the articles of impeachment. So kung meron na pala, bakit pa nila pinapasapina ngayon sa impeachment court? Is it because, I don't want to speculate, maybe I just won't go there. But ang sa akin lang po is, we have questioned this all throughout. No? Why? Because to us, unang-una, bawal siya. Pangalawa, hindi siya relevant. Bakit hindi siya relevant? Your Honors, transactions do not equate to wealth. Transactions do not equate to net worth. Especially if tinatali natin siya sa SALN. Because transactions happen over the course of the year, and in this case, years. Well, when you talk about SALN, we talk about net worth on a specific date in time, which is December 31 of every year. So sa atin po, ang aming pananaw dito ay hindi po relevant at hindi po, it will not directly show anything about wealth. Kasi, again, AMLAC transactions do not equate to net worth of a certain person. And that is why, Your Honors, we have opposed this. And we have opposed this since the time it was being presented at the House level. Thank you, Your Honors.
Just for the record and for the information of the Senator Judges, I'm not sure about the Sandigan Bayan issuing a subpoena every week as well against AMLA. But I'm well aware, the court is well aware of cases decided by the Supreme Court precisely on subpoenas issued by the Sandigan Bayan vis-a-vis the AMLC. Senator Judge Pia, can you wind up? You're done? At this juncture, Chair will now recognize Senator Judge Alan Cayetano for his interjection and questions. You may proceed, sir, when you're ready.
Before I ask question, Mr. Presiding Officer, may I thank you, the Senate President Win Gatchalian, former Senate President Tito Soto, and the whole court, because in our caucus, you did three things. One, you allowed us to have the weekend to review all of the laws so that we can ask more intelligent questions. Two, you allowed to hear the discussions, mostly by Senator Pia, Senator Pangilinan, Senator Lacson, and former Senator Soto. And then number three, we discussed how a complex, or what word did you use a while ago, Mr. Presiding Officer, that it's two motions, but there are
There may be issues underneath.
issues and sub-issues. So that after we ask questions and after you make a ruling, we'll instead of asking for a division of the House just in case we do not agree, I'll make a manifestation, and then if others agree on how we can manifest or submit in writing in what parts of the ruling we agree or disagree for the record. May I proceed, Mr.
Duly noted, Your Honor. You may proceed, sir.
Good afternoon, Attorney Jokna and Attorney Poa. Yeah. So I really want to be enlightened. I have no illusion na magkakasundo yung dalawang side today because you have the eloquent Attorney Jokno on one side and the eloquent no joke on the other side. So sa pangalan pa lang baliktad na. But I think the discussions are very important. And I do appreciate your opening as Congressman Jokno. I appreciate your oral arguments because I've been pondering this
these questions, what if, hindi ko na sabihin this administration, let's say in future administrations, this exact thing happens, 5 years, 3 years, 10 years, iba ang SALN, iba yung income ng COA chairman or ng ombudsman files cases about many, mukhang maraming congressman makakasuhan ngayon. So, very, very much relevant yung ating pinag-uusapan ngayon. So, just in the spirit of liberality, same kay Senator Pia, after one answers, if one wants to make a quick rebuttal, I'll ask you the question, but let's try to be concise. So, Council, may I ask, let's start with the case of Duterte versus House of Representatives. Thank you for reminding us about certain precedents and how I voted last time. But you would agree, diba, that when you have legal proceedings, even in legislation, you follow what the latest law is. So, for example, if you're allowed to issue a general warrant before Stonehill versus Jokno, but after Stonehill versus Jokno, so if before Stonehill versus Jokno, walang doctrine of the fruit of the poisonous tree, then some policemen will still submit evidence that was illegally acquired. But after that, we have to follow. So you did make your point about obiter dictum, I'll go to that, but I just want to start out by saying that the fact is there is a Duterte versus House of Representatives. So with your permission, let's start discussing that. So this case of Duterte versus House of Representatives came out after the impeachment of CJ Corona, correct?
Yes, Your Honor.
And the two elements was discussed in this case. The act charge must be impeachable under Article 11, Paragraph 2 of the Constitution, and 2, the act committed must be committed during the term of the impeachable officer. You commented on that. Can you elaborate or give your stand regarding, I think you agree with letter A, right? That the charge must be an impeachable offense. I mean, we all agree on that, right?
Well, I would distinguish, Your Honor, please, between what we would call ratio decidendi, or the rule in that particular case, and obiter dicta, which are side comments or incidental remarks made in the opinion of the court. If we are speaking of the ratio decidendi of the Duterte versus House of Representatives case, I would have to disagree that it relates to the statements that you mentioned. My understanding of that case is it really relates to the first mode of impeachment and the procedures that must be followed, the 1-year ban provided in the Constitution, how that will be applied when impeachment complaints are filed by at least 1/3 of the members of the House of Representatives. Yung pong nabanggit nila that the basis of any charge must relate to the incumbency of the official, in my view, that is obiter dicta, not necessary
I
for the
appreciate your
decision.
answer. We'll go to that. But regardless of the Duterte versus House of Representatives ruling, we do agree with letter A. The act charge must be an impeachable offense under Article 11(2) of the Constitution.
I would agree, but if I may be allowed to just qualify
No, this is just a
that.
general. This is not a trap question. So, so the officer has to be impeachable, and the act charge should be an impeachable offense. And since you have betrayal of public trust, that's quite broad. No? So this is not a trap question. This is just laying the basis. But go ahead if you want to comment on that.
Yes, the acts charged must constitute an impeachable offense, and that power to decide what is an impeachable offense is lodged exclusively with this honorable court.
Okay. So you disagree that part of the ratio decidendi is the act must be committed during the term of the impeachable officer. Thank you for bringing it up now, because I think all throughout the trial, especially in the articles where we will bring up acts before 2022, this discussion will be relevant, no? So by discussing this, it will pass upon the whether or not including proof like bank records, financial documents before her term can be inquired into. The prosecution says it cannot, right? Because you believe it's an obiter dictum. I'm just restating, but you can say it in your words. You believe that the statement that the act must be committed during the term of the impeachable officer is not the law of the land. It's an obiter dictum.
In the first place, if Your Honor, please, that was not the exact statement of the court.
Okay.
The court said the basis of the charge must relate to the incumbency of the impeachable official,
Yes.
which does not rule out the presentation of evidence of acts or omissions that occurred before the person became an
So
impeachable
let's
officer.
take the judicial notice of the, as you said more eloquently and correctly, that the acts during her term. So can you define, you defined this in your opening statement, but for the sake of this discussion, an obiter dictum is what?
It's a side comment, Your Honor, that is not necessary for the resolution of that case.
Yeah, and I agree with that, and it's a remark made or opinion expressed by a judge in a decision upon a cause, or it's a by the way, that is incidentally or collaterally and not directly upon the question before him, or upon a point not necessarily involved in the determination of the cause, or introduced by way of illustration, analogy, or argument, such are not binding precedents. No? Just for the public and for all of us, di ba?
Yes.
So ang sinasabi, yes, there can be a Supreme Court decision, but that part could be an obiter dictum, meaning hindi yan yung doktrina that will bind us in making decisions whether it's issuing the subpoena or admissibility. But are you aware of the Villanueva versus Court of Appeals GR 142947 March 19, 2002? I won't take it against both of you if you do not. There are thousands of cases. It talks about what is obiter dictum. Have you passed about on this, both counsels? Yeah, so the prosecution characterization of the requirement that the basis of the charge must be for impeachable acts or omissions committed in relation to their office during the current term of the impeachable officer as a
Bugat-bag mo ba? May kausap ko na si Teacher Maria. Ano daw? Oo daw, magawa daw siya muna. Pointers. Saan mo kay Daddy mga assignment, ha?